Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. And today I'm going to try to make something make sense that almost doesn't seem like it should. More on that in just a moment. So in the case of Linton versus Carter, which is in the Missouri Supreme Court, it was decided on November 23rd. It has an interesting factual situation where a child is born prematurely. There's a cesarean section. The child's leg is inadvertently cut during the cesarean section. And he develops a neuromuscular or neurological abnormality called PVL. And I won't go into the pronunciation and all of the medical terminology that relate to this. Basically, it's what's called a white matter injury, which means that on certain radiographic images, it looks white inside the brain. It's usually related to anoxia, although nobody knows for sure. And in this particular case, the issue for the court to decide was about causation testimony. Now, as I've probably said numerous times on here, when you have a case of medical negligence, you have to prove negligence, meaning that the doctor did something he shouldn't have done or failed to do something he should have done. You have to prove injury, which in this case is kind of a spastic quadriplegia, and developmental disorders that are related to this brain injury. And the third thing you have to prove is that the injuries were caused by the negligent conduct. And on almost every medical negligence case, there is less contested about the injury and about the negligence than there is about the causation. Because causation is the one place where it's generally possible for almost any lawyer to muck things up. In other words, if I can confuse you about whether or not this is caused by the acts of the defendant, it's more likely than not that you'll let my defendant go. And of course, that's exactly what defense attorneys do. And to a certain extent, a defense attorney is called to zealously defend his client. There is nothing wrong with him zealously defending the client. You might have some issues with regard to the doctors who sometimes give testimony that seems a little odd, but nevertheless, that's what lawyers do. They defend their clients, and in this particular case, they put on a doctor who said this injury could have occurred before birth, it could have occurred after birth, and I can't say which of the two it did. So the plaintiff's attorney said, I want to move to strike his evidence. I don't want his deposition played at court. I don't want him called to testify on causation at court because he can't testify to a reasonable degree of medical certainty whether this was pre or post. In other words, whether it's related to the negligence or it's not related to the negligence. And here is where another part of the law comes in and really starts to cause what seems to be an inequitable result. The bottom line is that whenever you are bringing a case, whether you're suing a doctor or another lawyer or the President of the United States, you have the burden of proof. It is up to you to prove how an injury occurred. It is not up to the defense to disprove that. They simply can offer testimony as to other causes. It doesn't have to be, it definitely is this cause, or it definitely is the other cause. It could be any number of causes. For example, let's suppose you have a person who has lung disease, for example, chronic obstructive pulmonary disease. And they go into the hospital and it takes a little longer than usual to intubate. Usually intubation is accomplished within 30 seconds. Let's say it takes them 10 minutes to get an endotracheal tube into the lung and as a result, the patient dies. Well, if the defense comes up with alternative causes, look, it wasn't this negligence, it's this guy's long-standing history of pulmonary disease. It was a Kobayashi Maru. There was no way anybody was going to save this man. That probably seems unfair if you really believe that the failure to get him intubated was the reason that he died. But it's perfectly legitimate on the defense side to offer alternative theories. You don't have to prove them beyond a reasonable doubt. You don't have to prove them at all. You just have to say, yes, that's a possibility. And under Missouri law, it is proper to offer possibility testimony when you are the defendant. When you're the plaintiff, you have to say, no, it definitively caused this injury. And in this particular case, the plaintiff's experts said, yes, it caused the injury. And the doctor's experts said, no, it didn't cause the injury. It could have been any number of things that caused it. I can't say what did cause it, but there are all these other things that could have caused it. And eventually what happened was the jury came in and said, there's no negligence here, and the doctor doesn't have to pay anything. Again, if you're the plaintiff, it seems a little inequitable. You have to prove it, and it has to meet all the standards for expert testimony. But all he has to do is offer alternative theories, and he can still win. And that's because the burden of proof rests with the plaintiff forever and always. They have to make the burden. They have to make the case. If they don't make the case, they lose the case. And that's what happened here. So it's an interesting case. I'm not sure I agree completely with the holding in the case. It's written by one of the newest judges on the Missouri Supreme Court, but it does appear to be well-reasoned, and it appears to be very well cited in terms of the authority that it relies upon. And as of now, it's certainly the law for the state of Missouri. So I hope you found that interesting, helpful, informative. If you have, I'd really appreciate a thumbs up. If you haven't already, please go over here and subscribe to our channel and tap that notification bell so you can be notified anytime we release a video on this channel. Thank you so much for watching. Have a wonderful day.